Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
And as Mr. Milton, is there a conflict or
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who's him?
Who's him? Who's him? Who's me?
Don't interrupt.
Oh, sorry, Judge.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
When are we going to break for lunch?
When are we going to break for lunch? We should break for lunch about right now. No. We have documents. We have documents that were sent to me by Jules and a couple other people as well. Thank you so much. Long time no see. Welcome everybody. Welcome. We need to get right to it because we have a podcast that starts in just under 2 hours and we have some documents to read. It's going to be a long day. Long day. I'm calling it right now. We have some documents. Let's see. There they are on the screen. Beautiful. You can see them. I can see them. We need to get underway. These are documents filed by the plaintiff
he's the guy.
Today in court in the Maya trial. Realize we have a big hearing. If you were on live with Dr. Joe last night, and he had,
how does he do that?
He had Nick Whitney on. We had a big hearing come up on the 15th. This is where the judge is going to consider all these motions for sanctions, directed verdict motions, motion to compel. Now we have a supplemental motion to compel. Do you know what that means? They've added some stuff. It got juicier. Judge, one more thing, Your Honor. Now you're going to consider all this. We've just got this brief 32 pages for you to review. Oh, that view is not going to work. Hold on.
Is that correct?
We've got to change this view to make it continuous scroll. There we go. Let's shrink it down. That's better. I can live with this. All right. Let's see. I'm on screen. It's on screen. Are you guys ready to go? Should we just go? You know what? We can't. Do you know why?
Have them send someone with more experience.
We need someone with more experience. That's what it is. No. That's not the reason. The reason is because John Boy was first in chat. First time offense for John Boy. Maybe he didn't know what was happening. Maybe it was an accident. Maybe he stepped in it and has no idea. But John Boy, you were first in chat, and as punishment for coming in and having the audacity to speak in chat, we're punishing you with the internet ownership, and you're responsible for taking care of everything IP related worldwide, including my new toys that I just got today. I just got these. Check this out. I just got. Can you guys read that? Mars Holy Land brand 4K wireless video transmission system. If you can't tell, I'm grinning from ear to ear. I love it. I love it. Anyway, so here we go. Let's kick off this document. I'm going to read it to you, John Boy. You just take the internet and make sure it works. Don't let there be any interruptions. And we're going to proceed that way. I'm going to make myself just a tiny bit smaller because I can do that. Is that about right? Then I'm off to the side there. Not getting in the way over here. All right, quick read through, and then we'll scroll through the attachments. But here we go. This is dated today in court. It was sent in this morning and just appeared in the docket. Courtesy grabbed off the court record while it was public and emailed to me for your listening pleasure. So here we go. Plaintiff's motion to compel and supplement to motion for sanctions. That means this is from the Kowalski camp. Okay, it means it comes from Greg and Nick. All right. Plaintiffs Jack Kowalski, as parent and next friend of MK, a minor, Jack Kowalski, and personal representative of state of Beato Kowalski, deceased, by and through undersigned counsel, hereby file a motion to compel and supplement to motion for sanctions and state. Here's what we say. Ready? We say, first of all, Tommy Jones, thanks for being a member for 6 months. No, they didn't say that, but I say that. Can't wait to hear this. Thank you, RA. Appreciate it, Tommy. Appreciate the 6 months of support. Number 1, on November 2nd, the court instructed defense counsel to produce by the next day at noon any and all documents with the scintilla of odor. It's even got the quotes, scintilla of odor related to the Joint Commission and or CMS between 2015 and 2019. And any and all documents related to the run-up to the finding or classification of ongoing immediate jeopardy as described by CMS. Number 2, on November 2nd, 2023, plaintiffs filed their notice of taking deposition Ducis Tecum of Angela Green, requesting those documents. Remember that. On November 3rd, Mrs. Green appeared for a deposition with defendant's counsel. Plaintiff's counsel left that deposition with approximately 8-inch stack of documents that had not previously been produced, despite the court's order. Number 4, the weekend following Mrs. Green's deposition, defendant's counsel provided an inventory of 2 additional boxes of documents in defendant's possession related to the hospital accreditation status and the finding of immediate jeopardy during the relevant time period. See Exhibit A. 5, on November 6th, defendant's counsel brought the 2 boxes of documents to the courthouse. However, as rebuttal testimony proceeded and jury instructions were read by the court, plaintiff's counsel did not have adequate time to inspect the documents. Again, on November 9th, plaintiff's counsel requested that defendant's counsel make the 2 boxes available for inspection at the courthouse while the parties awaited the verdict in anticipation of the punitive damages phase of the trial. See Exhibit B. Plaintiff's counsel explained the issue to the court before the jury was sent back to deliberate on November 9th. In response, the defendant's counsel said that he had not checked his email that morning, but would as soon as the jury was instructed to deliberate that morning. Defendant's counsel then informed the plaintiff's counsel that the boxes were transported back to their office in Tampa and wanted to discuss the scope and purpose of plaintiff's requested inspection. See Exhibit B. In response, the plaintiff's counsel informed the defense counsel that they wanted to see what else existed that was subject to the court's order and admonition to produce everything in italics. That's almost like a different font, but everything. Defendant's counsel stated that the boxes could be at the courthouse by 1 p.m. on November 9th. The jury returned the verdict shortly after 1 p.m. on November 9th, and again, the plaintiff's counsel did not have time to inspect the 2 boxes of documents. After the verdict was read, the court shifted to hearing final arguments on the jury instructions and verdict form for the punitive damages phase, as well as evidentiary arguments and the admission of the documents plaintiff had marked for the punitive damages phase. In short, let me get this updated here. In short, plaintiffs did not have time to inspect the 2 boxes of additional documents in defendant's possession between the verdict and the commencement of the punitive damage phase of the trial. After the punitive damage verdict was delivered, defendant again retained possession of the documents. They want these documents badly, and they have not had the chance to see them. On November 21st, plaintiff's counsel emailed defendant's counsel requesting a Dropbox link or similar digital file containing the documents contained within the 2 boxes, and requested that defendant produce the documents within 10 days. That was on November 21st. Guess what? It's been about that. We've been about that. On December 1st, plaintiff's counsel followed up on the November 21st request as the documents had not been provided. Shortly after, defendant's counsel responded and asked, "What is the point of this at this time?" Undersigned counsel responded and informed the defendant's counsel that 1, the court ordered all of these documents produced multiple times on the record. 2, we have a pending motion for sanction and we're entitled to know what was withheld. And 3, the defense was asking for a new trial. Defendant's continued failure to produce court-ordered documents solidifies plaintiff's position in its pending motion for sanctions. And the plaintiff has been and continues to be prejudiced by defendant's refusals. In fashioning the appropriate sanction, the court is guided by 6 factors set out in case law. And these factors are predominant. We're going to just focus on the bold one here. Whether the delay prejudiced the opposing party through undue expense, loss of evidence, or in some other fashion. That's what they're saying they do. So they're saying we were harmed. We were harmed in our case. And Jules, by the way, thank you for these documents. And USMC, I think, sent these as well. A couple other people sent them. Thank you to all who sent the documents. They say we were harmed. It hurt our case. It cost us time and money and effort, and possibly we possibly had things ruled out in our case, charges that were dropped because there was no evidence to support them that could have been granted. Okay, this is a big deal. It says it hurt us. The factors are all factored there. The causal factors are easily satisfied here, but the 4th causal factor involves consideration of the prejudice of the plaintiff's. Defendant's continued failure to produce the requested documents prevents the plaintiff from demonstrating the degree of the prejudice caused by the defendant's late production. The fact that they're not giving us the documents makes it hard for us to even say how bad it was for us, because we don't know what we don't know, Judge, and you ordered it returned over. Plaintiffs believe they were materially prejudiced in being prohibited from putting on materially relevant evidence that should have been admitted, rebuttal and punitive damages in the rebuttal and punitive damages case. But plaintiffs have no way of demonstrating to the court that the withheld documents contain material information that would have benefited their case. Plaintiffs also feared the destruction or loss of the 2 boxes. We're afraid they went to the paper shredder, Judge. We're afraid that they, instead of getting back to Tampa, they found their way to the landfill via the burn incinerator. They feared the destruction or loss of the 2 boxes of inventory documents and wished to preserve them for the appeal, whereas the defendant urges a new trial. Say, yeah, you want a new trial? Guess what we're going to bring? 2 boxes of documents. 2 boxes. Those 2 boxes of documents. Laura Bronson, thank you for gifting 5 memberships. Thank you so much. That's super generous. I appreciate that, and so do the people who received the memberships. I love how spicy that is, saying we want to use this for the new trial you want so badly. On more than one occasion, this court admonished defendants' counsel for its failure to produce the documents at issue. As of the date of this filing, plaintiff's counsel has not received a response from the defendant's counsel and has not received a Dropbox link containing the requested documents. Defendant's original withholding and continued defiance has not only prejudiced plaintiff's ability to present a complete case litigated fully on its merits, but is impeding the court's review of the appropriate sanction to be levied. Judge, this affects you too. Yeah? Judge, you can't proceed unless you know what they didn't produce. We all need this. Plaintiffs respectfully request this honorable court to enter an order compelling the production of the requested documents contained within the 2 boxes that were brought to the courthouse on November 6th and November 9th for attorney's fees and costs in having to bring the motion, and for any and all other sanctions the court deems just and proper. Judge, we want the boxes. We want them to pay for our time for all this to get the boxes, and whatever else you feel is appropriate. Just throw that in for good measure. Yes, Mrs. R.A.
Were the boxes sitting somewhere? They saw the boxes?
The boxes were in the possession of the hospital or the defense, and they said, we will show you the boxes, but you do not get the boxes. You can look at the boxes, but they didn't produce them at any time that the plaintiff could look at the boxes. And so they're saying, we deserve to look at the boxes. We want to know what's in there. It's a mystery box. Could be Pandora's box for all we know. 2 Pandora's boxes. It's an anomaly. Wherefore, plaintiffs, Jack Welski, and friend, everybody, parent and next friend of MK, Jack Welski, principal representative of the state of Beata, deceased, respectfully request this honorable court to enter an order compelling the production of the requested documents for fees and costs associated with bringing this motion for any and all sanctions this court deems just and proper, and for such further relief that the court finds to be justified. Signed, Greg Anderson, Jennifer Anderson, Nick Whitney. We're missing somebody. Sam, where are you at? So we need another name on there. And then we have Exhibit A. And Exhibit A shows the inventory of the blue box. And we've got documents, stuff that looks quite interesting. As you peruse through the titles here, I salivate reading the titles, thinking what the document and the pages contained therein might say. Yeah, lots and lots of stuff. So we'll scroll down through here and see if there's anything that really jumps out at us. Orange folder. We want the orange folder. We want the yellow folder. We want the green folder. We know they're in there. We saw them. As you carried the boxes out of the room. We've got 3 colors of folders we'd like to see. Another yellow folder. Yellow folders again. Yellow folders galore. We want all the colors. That should be like a veritable rainbow of folders in our box of documents once this is turned over. Let's see. Medical staff leadership. Pharmacy policies.
How do we know this stuff?
Because they were given, this is a summary. I think they were given a summary of some of the documents. But they didn't get to actually see them, and they'd like to actually go through, instead of just reading the table of contents, they'd like to pull out the pages and peruse them at their own will and pleasure.
There's a lawsuit.
And they're asking the judge, saying, hey, force them to turn this over. We know somewhat of what's in there, but you still haven't turned over the IJ, right? You still haven't turned over the real thing. Okay, we've got the sepsis. Sepsis is in the yellow folder. Nice. I guess that's where it goes. Patient safety quality dashboard. quality indicators. There's a lot of cardiac stuff in here. Performance review, feedback, and in a couple different areas. Hospitalist, radiology, critical care, not just cardiology, a couple different areas. Master reporting schedule. Oh, look. Event cause and analysis and review. That one's highlighted. Privilege information under Florida FL 395 and 766 and Federal Healthcare Quality Improvement Act and Patient Safety and Quality Information Act. We would like that one, please, as well. Thank you. Just a couple things that we'd like to review. And the funny thing is, like, you want this new trial so badly. This new trial, if you get a new trial, we'll have these documents. Let's see, the broadcast of the town leadership and town meeting that nobody knew about. Yeah, let's include that one. That's in there. We found that. The whole thing. Board Quality and Patient Safety Committee meeting minutes. Disclosure of adverse medical events. Standards and Credentials Committee attendance roster. Now, who was at these meetings? I love the highlight in here. Complaints or grievances from patient and family. Board of Trustees meetings minutes. This is all stuff that the judge has ordered be turned over. And we know that it relates to this because it leads up to, or it has a scintilla of odor regarding this IJ. And the hospital has identified that. They say, Steven says, look at number 68. Look at number 68. Exhibit B. Where's number 68? There's no 68. Go up. Did I miss it? Oh, up here. Number 68. Patient deaths list. Oh my goodness. So this is what should be in the box, I believe. Or this might be the list of what they turned over already. And there's more stuff in the box than this. We've got some emails. Hey, Nick. I'm going to be careful on this because this might have... we file a motion. This is the back and forth. Hill Ward. This is the defense lawyers team. This is Howard Hunter's team. What's the point of this at this time? He's just screenshotted all the back and forth. Please provide the Dropbox link. Can be there at 1. Yeah, all the back and forth of requesting the documents. Need to know ASAP what more you want, including whether to inventory boxes. Thanks. Thanks, Mr. Hunter. Love you. Oh, look at this. Samantha's name. She's doing all the work here. Samantha Lawrence, Esquire. Hi, Howard, she says. Yes, we would appreciate an inventory and organization of materials that you received in boxes yesterday afternoon. We would like the inventory on Monday morning and the boxes of materials available in the courtroom. Additionally, with respect to specific materials, we're looking for the following. The Quality and Patient Safety Plan dated September 20th, 2018. Reference page 18 of the January 11 CMS survey. This should include the organizational charts referenced, the Systems Improvement Agreement, and or the 12-month contractual agreement entered into with CMS following the identification of immediate jeopardy, any and all emails, self-reports of correspondence to and from CMS in connection with the December 2018 site visit at the Atlanta Regional Office attended by Ms. Green and her colleagues, any documentation or self-report surrounding the site visit, any and all emails, self-reports, or correspondence to or from AHACH, or AHCA, in connection with the December 2018 site visit at the Tallahassee Regional Office, attended by Ms. Green and her colleagues, any documentation of self-report surrounding this site visit, the abatement plan provided to the surveyors, whether CMS, ACA, or the Joint Commission, the complete survey findings and preliminary reports surrounding the Joint Commission's 2018 recreditation of JHACH. Signed, Samantha Lawrence. Good stuff here. So this is all the exhibition. This email, this is not the request, but this just shows the back and forth that they had between the two parties. So this is added to the the big heaping pile that the judge has to review on the 15th. It's really bad to violate a court order 4 times. How do you get out from a sanction, out from under a sanction, where the judge has had to take 10 minutes of his time explaining in detail to you how to not screw up again, and you do it again? How do you not get your hand smacked over that one? I think there's going to be some sanctions. I don't know what the judge is going to do. He has the authority to do all sorts of stuff, but something is coming up, and I wanted to. Hey, Megan, you joined us. Good evening. I wanted to go over this because you guys were screaming for this document and saying you've got to go over it. And it was short enough that I could do it very quickly. It's basically a staple to on the back of what the plaintiff has already filed in the initial request motion for sanctions. This is like, and another thing, and it's updated, right? Because the first sanctions thing, we didn't know all these things had happened, and now it's like, and currently we still have not been provided this, and this is the effect. But great stuff. Megan, someone was saying today that we need to do a read through of the 15th. Oh, that looks just awful. You guys see that? On the 15th, there's going to be the hearing. Where can I put this so you can read this? Oh, maybe if I do this. Let's just get rid of that page. Let's see. I'm going to scroll. Mozzie66 says, Judge's scintilla of evidence order has been totally disregarded. Judge, so as to be unhappy as the plaintiffs. Judge, so be unhappy as the plaintiffs. Yes, it's been bad, and I apologize. That looks so awful on this screen. Maybe if I switch to this camera, it's a little easier to see. But Megan, someone was suggesting we do a read through of the events that happened on the 15th, because as I understand it, there won't be any news cameras in the courtroom. Hopefully that changes. Hopefully there's enough interest that people will do that. I can try to do what we do on the sidebars issue, where I just repeat everything I hear on Zoom over voice. But if that's a 2-hour hearing, basically my brain will be dead. That'll be my last and final act and gift to you guys before I die, because that's a lot of work to try to repeat everything everyone says for 2 hours and do it properly. So we can try to do that a little bit, but possibly after the fact, if we can get a hold of a transcript, that would be awesome. I'm not sure if you're interested in that. We want you to include RA in next read through. I nominated RA to play the part of Hunter because he is so not like Hunter. You nominated me to be the bad guy. We were going to like dig in the bottom of the barrel and find somebody who didn't know anything about the case and just like, oh, you get to be attorney Hunter. That's your role, and not tell them what that entails. Covering the hearing on the 15th. Yes, we are, Laura, but it's going to be tricky because of the court orders and everything. So we're gonna try to see what we can cover live and what we need to cover after the fact. Adam's like, it's a good way to go out. I approve. I'll rubber stamp that. It's a 4-hour hearing. Man, I'm going to need headphones because I can't hold my phone to my ear that long. I'll get cancer. Here's what we can do. I can tell you this. On the Zoom feed, we will be sharing out the link to the Zoom feed for those who want to watch it live if there's no media coverage of it. But you have to understand, the court has ruled that nobody can rebroadcast that. So we can't take the audio and let you hear it. We can't take the picture and let you see it. We have to give an account of what we observe, and that's the closest we can do. If you violate those terms, basically, I don't think the judge could come and extradite me from North Carolina to Florida, but I would probably never get access as media in that courtroom again, or possibly in the state of Florida. And it would also probably harm the society as a whole, the true crime society as a whole, for live streamers, because if people like me push the envelope when we shouldn't, they'll push back, and they end up winning because they're holding all the cards. Fiona, thank you for the super generous super chat. I appreciate that very much. Thank you. Look at burner, says Tommy Jones. I'm looking at the burner. Hold on one second. Was it a text message? I've got a please message. Was that from you? Do the Maya documents during the podcast because I'm going to make my husband watch. You wouldn't by chance. No. What time the meth call happens, would you? I want my husband to see. Yes, I can tell you it's right between the opening statement on the Hannah Payne trial from the from the prosecution and the defense. It's during that break that we got the call that I pranked in reverse. The court has stated on the new doc, no court live, only Zoom. Yeah. So that's going to be, I think the best I can do is give a recount of what's happening live, and we could probably give out the Zoom link to everybody where we can each individually watch it. We'll need 2 devices. For those that aren't able to watch it, they can listen to my recount of it. For those that are able to watch it, we could probably come together on a channel and comment and about what we're watching on the other. It's a little awkward. It's like a watch party. I'll probably have to ask some people to see if there's a good way to do this. Let's see. We have Rhapsody in Blue 111 says, I just wonder when enough will be enough for the defense. At what point will the hospital step in and tell them to back off and let it go, if ever? Rhapsody in Blue, if you were watching Dr. J's interview with Nick last night, I think he had a key point. Dr. J, what did I say? I know, it's Dr. Joe Corcoran. I call him Dr. J, sorry. But Nick said basically as soon as the judgment is entered, okay, the money becomes due. Bam, payable now. And not only does the clock start, but the interest starts. And that interest accrues at a set rate that's updated every year. And it equates to like 20 million a year. 20 million. I think it was 20 or 2. It's a lot of millions. It's a lot of millions, and it goes fast. And at some point, they have to look at that and say, we could fight this for 2 years. It may be 10 million. I forget. Yeah, Nathan says 20 million a year in interest. That's what I heard as well. Cannot play it delayed. I can't record it. I can't show you a picture or anything. The rules are pretty tight. But we can get everyone on Zoom to watch it. But we'd wait till it becomes live and make sure there's no other feed. Because honestly, I think it'll crash their Zoom. Joy says, I caught RA live. I watched the whole trial through your streaks, and after the fact, I'm finally caught up. I wasn't streaking. What, Joy? That was a different channel. I think you've got us confused. I'm just kidding. All right. As soon as the clock starts and the money starts adding up, that is just additional money they have to shell out. And they might be able to reduce it by a little bit, but at some point the cost benefit just doesn't work anymore, and they just need to pay up. So we'll see what happens. Watch party at my house, says Lat Cali Girl. It's going to break Zoom. Brooke, I've used the pro versions of webinars, and I think they're limited to 500 participants. So here's what I want. I want to be able to get in because I'm going to be repeating it for other people. So I'm going to be in early as quick as I can. But if nobody else is able to get in, if 500 people join, then there will be a lot of people who aren't able to get in. I don't want people to be joining if they're not actually, going to, observe and comment and things like that. So I hesitate to just give it out and say everyone flood the Zoom because we don't want to bring down the Zoom or keep people who have a legitimate reason to be there from being there. Defense just dropped an objection doc to this motion just now. Where's Sarasota County? Bring it up. Where are we at? Florida. ClerkNet. Log in. Search. That's me. Recent cases. That's the one we're going to. We're going to scroll down. Let me see what the defense... defense had to write this today, right? You had to be super quick. There it is, objection. There we go, and it's open to the public, so we can show this one too. We're going to go ahead and download this one while it's free and available. Let's say def obj. We're going to put that right on the desktop. Okay, this is shorter, I think. Let me see. Let me scroll through really quickly. Oh, they've spelled out certain things that they want. It's mostly exhibits. Okay, here we go. Let's bring this over. Just 1 second. We get a bonus doc today. Okay. Pop this open. What are you seeing my desktop? Are you seeing? Oh no. Okay, that's good. I mean, it's not a bad thing, but I like to know what you guys are looking at. All right, here we go. Let's go. This is the defense objection to the document we just heard. And Magical Mary, thank you very much for alerting us that this just barely popped up. One more thing, if you've ever been to an Apple event, we've got one more thing here. This is filed by the defendant. Go full screen so I can read the small print. Defendant's objections to production of black and blue boxes, Joint Commission docs. The black and blue boxes. We're talking about colors here. So they don't think it's all rainbow. They just think it's black and blue. Defendant Johns Hopkins All Children's Hospital Incorporated, by and through undersigned counsel, states that it is in the process of reviewing and preparing for production certain documents preparing to Joint Commission and CMS reviews conducted of defendant in late 20. Oh, this document's viewed wrong. I need to continuous scroll. There we go. And smaller. It's in the process of preparing for production of certain documents relating to the Joint Commission and the CMS reviewed from late 2018 and early 2019. Defendant states that it objects in general to production of these documents. Your Honor, it hurts our case. Inasmuch as the same are completely irrelevant to the above-styled cause, particularly in post-trial proceedings, and as such are beyond the scope of permissible discovery, defendant incorporates by reference in this regard its supplemental disclosure and motion for clarification and response to plaintiff's motion for sanctions and cross-motion for sanctions with respect thereto. So here's our reason why we don't want to do this. Defendant further states that such production, as it indulges, notwithstanding this objection, is strictly subject to this court's previous confidentiality order, and the material produced must be reviewed and then promptly returned. You can look at it, but you can't keep it, right? In addition, the following information documents from the boxes were made available during trial of this matter during trial of this matter is objected to upon the basis stated, each having reference to the item number on the inventory attached hereto as Exhibit A, and made a part hereof. So they've pulled items off that list we watched, right? Man, this was hurried. There's not much in here. They pulled items off the list and they say, we object. This is the first one is work product, attorney-client privilege, prepared in anticipation of litigation and trial, also peer review privilege, patient safety review committee privilege, work product, attorney-client privilege, patient safety, objections subject to peer review committee, peer privilege pursuant to section. These are all the reasons why they don't want to produce things. Various medical records. Objection on the basis the document contains substantial non-party patient information. Disclosure would violate HIPAA. They're valid. These are laws. These are laws on the books. They're not making up excuses. They're saying these are the reasons why we should not produce this. But just because there is a law that says you can't give this stuff out does not mean a court cannot order it to be released. Various medical records. Objection on the basis the document contains substantial non-party information. Lots of non-party information, HIPAA, non-party information, HIPAA, peer review privilege, more peer review privilege, work product, attorney-client privilege, more work product, peer review. It seems like they're using three main objections. They've got the peer review privilege, work product, and non-party patient information, so HIPAA. And let's see, governing body, peer review. See if there are any other objections to all of this. And man, we've got pages and pages of these. I'm reading fast, you guys. I apologize. Lots of documents. HIPAA, peer review.
Okay, so basically they're saying you have to dig through each individual one and come up with a specific reason for us to release every single one.
No, they're saying these are the reasons why you cannot release each one. Each document, this is the reason why this specific document cannot be released. We object because it violates HIPAA. We object because this is work product that we are preparing our case, and this is basically our notes for the trial, and you can't look at our notebook. We object because this is a document that contains, it needs to be peer reviewed. Anyway, they get to the end of this list, and they say, defendant states that it is producing the materials produced during trial and has produced hundreds of other pages of materials in response to this court's intra-trial orders, subject to the objections noted above, and which were made at the time of the trial. I certify this, Mr. Hunter. Where, Mr. Hunter and Mr. Hughes. Where is Mr. Shapiro?
He's on vacation.
He's on vacation?
But I mean, basically what they're saying to...
Can you guys hear Mrs. R.A.? Thumbs up. Is Mr. Shapiro still work at the firm? I'm asking for a friend. Maybe that vacation that he was so set on taking might be a long one.
What they're saying with all of these objections is, Judge, if you honestly want this to have anything with a whiff of a scintilla of problems, whatever, then you need to come up with specific reasons for each of these to make us release it, right? This is their sort of last-ditch effort to say, you can't, this doesn't have a whiff of a scintilla of a whatever. He said, you can't do that. These don't count.
Hey, so Mr. Hunter says, I've smelled these boxes and they don't stink, is basically what this form amounts to. I sniffed all these things and they don't stink like the IJ, so you don't get them. But the hospitals identified all these lead up to them. This is all documents that were cited, documents that were investigated, documents that talk about it, that were reviewed as part of the survey. This is all IJ. This is everything. Anyway, 17 pages of juicy goodness in response from the defense, and all this has to fit in the 4 hours that we're going to have Judge Carroll's undivided attention on the 15th. Now we do know from Nick Whitney that what we're expecting is the judge not to rule on any of this on the 15th. Zero. He's going to listen. He's going to ask for argument. He's probably going to ask some very insightful questions, as he does. But when it comes to actually making a decision, that's going to come later. He's going to say, I'm going to take this under advisement. Did you read the affidavit from Jules? Yes. You're talking about the, let's see. Nick Will and Dr. Jones the other night said judges allowing streaming of Zoom on the 15th. Okay, I went back and I watched that again. I will say I love Nick. Nick's an amazing attorney. I think if he read the rules that I have read, which are not about how attorneys operate in court, but how camera people operate with the court feed, he might see that the judge has not authorized that yet. We're still trying to find our way through that, not around that, but through that, and see if there are some other options to even file and get permission. Sometimes, as I have done in other courts in other states, I've petitioned the court and been granted permission to restream the court's feed, even though nobody else is allowed to, or very few other people are allowed to. That is an option, and so we're going to try to do that as well. If we're granted that, we will live stream the video feed. But we need the judge's permission to grant that. Recovery addict telling Nick to stay in his lane. I would never, Greeners. I would never. You don't just tell the Nick Whitney to stay in his lane. You don't just do that. But I did a little bit. Sorry, Nick. Nick, I trust your judgment. I can make it happen technologically speaking, and I think that's what he was talking about. But I play in the permissions and decorum side of courts, and Nick plays in the well, and they're very different. So we'll work our way through this. Have we written Judge Carroll yet? No, we're looking for a document. We're looking for the right form. It might have to reach out to his clerk first, find the right form. Don't need a media lawyer to make a motion. We're not a party in the case, and we've seen this in other trials where a media lawyer will represent a large group of media outlets, like what we saw in Idaho in the Vallow Daybell case, and make a motion, and it's sort of weird because the judge is like, and who are you, Mr. Third Party? And they're like, we're an injured party because we'd like to broadcast this, and you're not letting us. And he's like, you're not a party to the case. So it gets tricky. A lot of times this can be filed just in a motion with the court, with the clerk. Sometimes it has to go and get reviewed by both parties, by the plaintiff and the defense, just to see if there are any objections there, and then the judge might be able to rule. We are media. That's what I got my degree in. I've practiced being media my whole life. We are the entire internet. Becca, you're right. The entire internet. If they watched it on Recovery Addict, it's the entire internet. Since you mentioned the defense motion, could that infer with a motion to get access to stream court? No, Felicia, I wish it did. It might, if this were like a closed hearing where it was not open to the public, being mentioned as somebody that did wrong might get me in, but I don't think I was even mentioned close enough to that to get past that barrier. Shapiro's still on the case. Hopefully he's having a wonderful vacation. Honestly, I don't wish anyone to have an awful vacation. He's with his family. I hope it's good. Oh, but recovery addict is in the defense's motion along with the de facto agent advocate notorious Jules, says Jules. As Kurt would say, notorious. All right. That is, I think it's just not being broadcast by network. Nick is thinking that it's okay to show over the net. Just thinking. Yeah, we'll get it sorted out. I don't want to give out the, there it is, Kurt. I was saying it for you. I hear you in my head when I say this, Kurt, but it's wonderful. Kurt, are you doing a live tonight? Are you going to tear this apart or explain it in better ways than I can? I've got a podcast that starts in an hour and 15 minutes. But they're little short little documents, so I'll sort of be competing time wise for same viewers if you do go live. But I'd be happy to if you're planning on it, I'd be happy to send people over your direction because I have to eat a little bit. Hour 15 is fine. All right, turn on the camera, warm up the lights. Send them to me, please. Jules, Jules, my friend, Notorious, are you there? Okay, let me get this off camera so I don't out Kurt. Okay, so everyone's favorite lawyer at gmail.com. Just kidding. Give me a minute. Let me see if I can get these sent over to you in just a bit. Where are they? Hold tight, guys. This is hard work. Let's see, JPEG, PNG. We're going to have doc number 1 and doc number 2. Okay. And Kurt, I've got to find your email somewhere. Give me just a second. Does Ari run his stream from that tiny laptop? Darth Raven, no. I run my stream from, let me take this off the screen so you can see, from an ATEM Mini Extreme ISO hardware switcher. This is an 8-port HDMI switcher and an encoder. There's also another 4-port HDMI switcher down here that feeds other things and runs some of my green screen and things. I could shut this laptop down completely and the feed does not stop. It's completely not connected to, I mean, I can monitor the feed that way, but it's not connected to the stream at all. All right, give me a second, Kurt. Can you, I'm trying to see I'm forgetting how to send it to you best. What's the best way? Or Jules, do you have both of them? Would you be able to send them to Kurt? R.A. scoffs at internally. Yes, I'm a hardware guy all the way. I would do hardware in a heartbeat. And Kurt, I got new toys too. This is a wireless transmission system, SDI and HDMI 4K wireless video signal with 40 milliseconds of delay. Super fast. But I need that for a gig that's coming up. Let me see who I can send these to. Forward, include. Let's see. I also have an orange pop filter, and that's exciting. That is really cool. Oh no, it's cool. Darth Raven, I'm happy to share information about my setup. I over-engineer everything. Kurt, I'm looking for your. Let's see. Let me send this via. I'll send it via text message. Does that work? Okay, here's the first one. Let me get you the second one. Send to my phone. Come on, there it is. And this one's going to go as well. I send them both. Text is also fine. I send them via text. Hopefully it doesn't downgrade the quality too muchly. Okay, so here's what we're going to do. I have a podcast that happens in just a few minutes. RA is ordered to produce the 2 documents to Kurt. Yeah, but is it like a motion to produce or order to compel? Or is it just like we'd like you to? Hey, what's sharing documents among friends, right? Of course. All right, let me watch and see if Kurt has a live. Kurt, I'm ready to pull the trigger when you are. Just saying. I'm not sure if you've got a second to pull this up. Kurt, the benefit of going and watching Kurt, stream is set up for the redirect. Thank you. Awesome. That is really cool. The benefit of going to and watching Kurt on this one is because you have the benefit of having a real lawyer who will be able to dive into this and really tear it apart from a legal mind frame and see some of the things that us lay participants in true crime addicts might not pick up on. So I highly like that. I've got you set up on the redirect, Kurt. So we're going to go over there now. I'll be starting my podcast at 8. Hopefully a couple of you can come back over and have some fun over there. Kurt, take it away. Have some fun. I'm going to play some music so we can make it official, because nothing's official until the music goes. Music goes. Kurt, are you in Texas or Virginia? Time for the air drums as well. Texas now. Wonderful. Licensed in both states. Practice law in 2 states. Man of many talents. All right, we're going to portal over to Kurt's place. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. It'll be 8 p.m. for the podcast. Till then, Kurt will take care of you over on Uncivil Law as he tears through these documents. Once again, and picks out the juicy bits that I skipped right over. So that'll be wonderful. Thank you so much, Kurt. I appreciate you doing that for all of us. And we'll see you guys later tonight. Please hit the like button when you land there on his page. Hit the like button. Say something nice in chat. Maybe even share the stream out. That would be great to have a good group over there, and have some fun. Be nice to him like you are to me. That would be great. Appreciate it. You guys have a good one. We're going to portal here as soon as the music stops and the feed drops. Wait for like 10 seconds, and you'll be moved over. We'll see you guys in a little bit. Bye-bye.